Okay. Welcome everyone to Protect Your Profit, Mastering Fair Agreements and Conflict-Free Collections. We have our very own Bill Hulsey with Boston Business Mentors giving our presentation today, and we're very thankful for him volunteering his time to talk about this important topic. If you'd go to the next slide, great. If you are new to Boston Business Mentors, quick recap of what our goals are. We're here to share information with the small business community so that all small businesses can be successful. We do that in a couple different ways, workshops and webinars. Our primary way we do, like I said, workshops and webinars. We do strategic roundtables. We also have networking events posted to our website, newsletter, and social media. We also have a lot of great information on our website, templates that you can download, a lot of really great articles, and we've started adding podcasts as well. I think our blogs are pretty great. There's a lot of really great content. Some of them are written by our own volunteers, some are written by third parties that we are partnering with. Many are very relevant to today and industry specific in some cases. Without a doubt, the most important thing we do will be our mentoring. And mentors can play a variety of roles for you. They can be a sounding board. They can be someone to help you find resources to overcome challenges that you're facing. And they can help you plan for the goals that you're trying to achieve. Whether you're in the beginning stages of just getting started, or you're in the growth phase, or you're ready to exit your business, we have somebody that can help you. We have over 40 volunteers with a variety of skill sets that come from all different industries. So I know we can find someone that can answer your questions and help you be successful. So I will go ahead and I'm going to turn it over to you, Bill.
Great. Thank you, Teresa. Let me just add, because I know a lot of these folks. You're getting access to C-suite executives, people who have owned and successfully ran and sometimes sold their own businesses. So they know what you're up to. They've been there. They're highly authoritative and I guess I would say highly accessible in terms of wherever you are, they're going to meet you there and help you solve the problems that you think are important and maybe sometimes raise some issues that you hadn't thought of yet. So, with that, I will move on to today's agenda. And just let me start with an overview that it kind of breaks my heart. I've been doing this mentoring stuff for almost 10 years now. And it breaks my heart when somebody comes with a billing dispute or a contract dispute that in retrospect probably could have been resolved or prevented. And so, talking to Teresa and some other folks, I said, well, why don't we put some things down to try to do that? And that's the goal of today's group, is to identify some things that you can do so that you don't have to talk to somebody like me further down the road. So the first part is going to focus on negotiating and enforcing your clear and enforceable agreements. We'll talk about the necessity of an agreement and some of the terms you want to see in there, and a resource, our friend John Ballinger, our colleague, who can help you. Then we'll talk specifically about locking down those payment terms, negotiating those terms, and enforcing payment. And then another critical term about scope of work, SOW performance, and getting those payment milestones. And then we'll talk a little bit about the continuum kind of dispute resolution, from things aren't going right, but how do I get this back online, to obviously the worst case where you feel like you have to end up going to arbitration and or court. So if you have any questions at the end, I guess you will have an opportunity to email those in or raise them at the time. So, as I said, too many small businesses lose money because of their contracting practices and their inability to effectively resolve disputes concerning performance and payment. It happens a lot. And again, we're going to try to address some of those reasons today um, as we go through this. One thing I want to point out now for you is that John Ballinger and I, who's a colleague, created a full suite of contract agreements that you can use. You can tailor them to your needs, but they cover a lot of the things that we're going to address today. And so, if you're running without a contract, or if you want to make sure your contract is touching all the right bases, connect with John at the email here, and he can help you make sure that your contracts are protective of you and clear for you and your clients. So the the old saying, I'll raise it first, that an oil contract isn't worth the paper it's written on. I think a lot of people, especially smaller businesses, newer businesses, don't want to look too formal because they think it's maybe will frighten the customer or so on. And I'd like you to think about it a little differently, which is you tell your client or whoever you're negotiating or contracting with how serious you are about this arrangement by the way you approach the terms of your agreement, of your contract. So just kind of, yeah, we'll get to it and don't worry about the money or don't worry about when the work gets done. That's not the way you want to represent yourself. And it's part of your branding, it's part of your desire to tell your community, whoever that is, that you're responsible, you're reputable, you're professional. So a contract is a good thing in many, many respects. And quality contracting is, I think, just as important as the quality of the goods and services you provide. And since our goal today is to talk about how to not lose money, when it's done right, it's going to keep your customers happy by clarifying what it is they expect from you and you from them. They'll save you time in not looking to get paid for money that is owed. And certainly, if you do it right, it's going to really reduce the number of times that you end up in a more adversarial dispute with someone um, over payment. Either you being the payee, you delivered the good or service, or you being the payor if you hired a contractor or a subcontractor. And just in terms of tone, because I think what a lot of people, as I said, is scared off by in terms of a formal document that may look too intimidating. And by the way, the ones John and I worked on are not 40 pages of boilerplate. They're succinct, they're accessible to anybody in terms of their language, and they're not lawyerly and legalese. But you can have business-like and professional agreements without becoming adversarial 99% of the time. And I always recommend this book. I think the our group offers training in business negotiations, but the old classic book, Getting to Yes, is just a wonderful way for you to. It's very short. You can get a online one, the original one for $1 used, and it's just a great schema or format to follow when you're talking to somebody about a negotiation over your business, your contract, or what have you. So I can't encourage that book enough to you. So, what are the key business terms every good contract should have? And it surprises me how often people come and have a dispute and they want me to help them think through how to resolve it. And so I say, well, what's your scope of work? What did you and the client agree to about what was going to happen? What was the time frame for it? What are the deliverables? Were there specific checkoff interim milestones or deliverables? And again, I think because people don't want to come across as too formal or businesslike, they'll say they don't have it. And that's where you start your dispute because the person on the other end may be hearing something different than what you're saying. And so you get started, and at a certain point, it looks like you didn't actually have a meeting of the minds, which is the point of a contract about that. So I always like to tell people don't worry about the boilerplate, warranties and all that stuff. Negotiate your scope of work, which will include the next two items as well, and get that nailed down so that you're both clear on what's going to happen and when. And then you can kind of tack the boilerplate onto that because really the scope of work is what you and your client are both excited about, which is getting your service or good or you hiring somebody to do something for you. So, in addition to the things I'm just going to use the example of you providing the good of the service. So, in addition to the scope of work, you want to be including in this document the compensation type. Are you going to be fixed price, time and materials? How are you going to address change orders? Things come up, or the client decides they'd like to see something a little differently. All of these things are ways not only to manage your risk, your financial risk, and let you step back and say, gee, have I priced this appropriately? But it also helps deal with a situation that can come up where you both thought something was going to happen and something didn't happen quite that way. And now you need to change the work or change the delivery schedule. But somebody has to take on the risk associated with that, the risk of the time, the delay in payment, risk of delivery of the good or service. So this is good things to have in there to address that. And the final one is a payment schedule with a deposit, interim payments, final payments. The I think it's in the, let me just see here. Whoops, I think I went the wrong way. Oop, I seem to be going backwards here. I'm sorry. Okay, so let me remind you, I'm sorry for that little snafu there, that you are not your client's bank. And when you're thinking about payments, when you're thinking about setting up a payment schedule, if the client can't pay you a deposit and make interim payments to you, you have to ask yourself and maybe them why you think they're going to be able to pay you when the job is over. So, one way to start to limit your risk of not getting paid or being underpaid is to simply require a deposit, very common, require interim or milestone payments as I deliver this part of the service or the good, and you check off that it's acceptable. You're going to make a payment to keep me up to speed. And then there'll be a final payment on final approval of the work. So, again, don't unless you really, or if it's a 1 day thing or something really short, that's one thing. But if it's a sequential project with more than one piece or to take place over time, then you really want to be making sure that your payment schedule is kind of running on the same chronology or calendar as your delivery schedule. So, in terms of the actual legal boilerplate of the contract, you obviously want to identify who the parties are. And the little subtext here is that if you, as we often recommend people to be, if you're a business entity, an LLC or a corporation or a partnership, you want these contracts between your business entity and the other side. You don't want to take on personal liability for that stuff because personal liability can result in loss of profits, loss of revenue, and so on. So if you're a business, do that. Remember that a DBA is not an entity, and if you're a sole proprietor, you're personally on the hook. So we have a great team in place to help you set up and talk about the right business entity for you, and then to help you set that up. The term of the agreement, if it's a 1 day thing, then that's one thing. But if you expect to be delivering goods or services over time, you should put that in. We won't go too far into this, but you're managing your risk, and John can help you with this too, through clauses about limitations of liability. If you're doing a $500 job for someone, you don't want to take on $5,000 of liability. And you want to talk about indemnifications, which are clauses that fairly allocate risk between the parties. If you're delivering a product or a service that the client expects some guarantees about the quality of the work or the merchantability. Let's say you're making something that they're going to take out and resell. You need to say that, these things are taken as is, and I'm not going to, it's your responsibility to look at the specs and make sure this is satisfying your needs and so on. So then you want to disclaim any warranties that aren't appropriate. And then finally, and this is back to dispute resolution, is make if you're in as wherever you are, but if let's just say Massachusetts, you want your choice of law, you want your disputes and the parties to agree that everything's going to be resolved in Massachusetts, especially today when people are working a lot online and serving clients all over the country or even the world. You don't want a client in California who thinks you're going to go out there and seek to collect or litigate a dispute if you can't get it resolved otherwise. So again, I can't stress this enough. You're not the customer's bank. If they can't make a deposit, if they can't make payments, what makes you think they'll be able to pay you at the end? And that goes back to your contract and being respectful but clear and professional with your client to say, look, this is how I need to be paid in order to do this job. And if clients start balking at that, maybe you're not getting the right kind of client in because clients that expect you to kind of do the work and then hope or take it on a promise that you'll get paid at the end, those are often the ones that I end up seeing who it turns out didn't get paid. So again, you can say these things, you can use getting to yes, you can be respectful, you can be professional, but still make those terms an expectation of your business. So as I've been telling you, the number one way to manage disputes over performance and deliverables is to clearly address them in your contract. In other words, to avoid them. Have those discussions up front, really give some thought to what it means that if you're going to do a job or deliver a service or build something for somebody or whatever, that you've thought that through. It serves a good goal to clarify with you and your clients about what goes on, but it also will make you sharpen your pencil about what is this project really going to cost. And so how should I be pricing it? Am I pricing it appropriately now that I sit down and say, gee, it's going to take me 25 hours and $500 in materials to get this thing done. So how do I price that appropriately? So moving ahead, it's not uncommon, despite the best efforts of your SOW, that you your client falls behind. It's more than one event, and you've got some interim payments or whatever. So you want to keep a good relationship with your client, but you need to get paid too. And again, I'm going to say this over and over. You're not the customer's bank or your client's bank, but you can be a little flexible. And this is the time to really bring your getting to yes or similar professional, non-confrontational skills in and say, look, we're falling behind. You're falling behind on your payments. And I can't do business that way because I have people that I owe money to as well. And I have commitments financially. So, what can we do to get back on track would be the way that you would start that. And then you would ideally get some concrete result. How are we going to solve this problem other than, well, I don't have it right now? Because I think at the point that you're told, I know it says that in the contract, but I'm not going to be able to pay you right away, or I've got these other things coming up. I think you have to decide if you're going to take the risk of non-payment versus telling the client that you're going to stop work or delay a deliverable until things get up to date. And that feels like an adversarial moment and a confrontational moment because you're saying, well, you don't get what I don't get what I want, you don't get what you want. But the reality is when that if you can't get the customer or the client back on track to paying, you really lose leverage if you continue to put your financial time and effort and resources into delivering this project and getting deeper and deeper in a hole in terms of what they owe you. So you need to decide what's the best thing to do. But if you can't, after explaining to them why you need to be paid according to the contract that you executed, you know, my advice is to tell them, look, I'm not here. I can't subsidize you. I've got my own bills. And so therefore, I'm going to have to stop work on this project until we can get back up to speed. Now, the little caveat there is if you're working oftentimes for big companies, they have a 30-day net payment schedule anyway, so you have to work that in. But if a big company starts getting in arrears on their payments, you have to approach it the same way, because all you're doing is putting your asset, your risk, your time, your money, your effort at risk into ultimately not getting paid or falling into a more cumbersome dispute resolution process that we'll talk about here. So keep track of where you are. If you're getting in arrears, uh, let that be a little red flag to you. And obviously, don't let it get to be too big of an amount. And people I know want to do the work and they're worried about keeping their customer happy, but it's a two-way street and they should be worried about keeping you happy too. So this is an opportunity in a non-adversarial way to stand up for yourself and again, mitigate your potential loss. As I said, start with getting to yes. Let's identify the problem. I need to get paid. Let's brainstorm some possible solutions. Do you want me to modify the scope of work? Do you want to buy the materials directly? That's not always a great one, but the line from getting to yes is be hard on the problem, but easy on the people. So you're not adversarial with people at this stage. You're simply saying to them, we have a problem. I need money and you're not giving it to me. So how can we work that through? And again, if there's dissatisfaction, this is a time to get that on the table. But if you need to prepare yourself to dig in on this phase and realize that if you haven't gotten a satisfactory outcome, you have to ask yourself, what is my, and this is a term from getting to yes called BATNA, what is the best alternative to a negotiated agreement here? If you can't resolve things and you're in an impasse, what are you going to do? You can stop the work entirely, you can terminate the agreement, um, you can look at the terms of your contract, which you'll have in the boilerplate about your dispute resolution options, mediation, arbitration, or litigation. But this is at the point where you've decided that one of these steps is your best alternative, that whatever's you and the other party have tried to negotiate isn't going to be satisfactory to you. So you're going to want to move on. So let me just talk you through these. They're probably pretty straightforward, but the first one is mediation, where you would go to a third party for voluntary. These are non-binding. A lot of times, the courts here in Massachusetts, particularly at the district court level, for relatively sizable cases, will make that mediation service available for free. And then you will sit down and the other side will sit down and a mediator will try to go back and forth and see if they can't either get the deal back on track, or if you're at the point where you're just trying to collect your money, either on a terminated agreement or you've delivered all the services, they'll try to help you reach an agreement there. Um, so it's a useful service. A lot of times I feel like if people agree to go to mediation, that means they're agreeing for some flexibility, which can be a grounds for some optimism. So the next phase, and this is kind of a binary thing, but your contract, you're going to have to think about whether you want to agree to arbitrate, which is a fee-based, private, and binding adjudication of the dispute. It's quicker, it's cheaper than litigation and in both respects of time and money. But it is not cheap because you pay the arbitrator to make the binding decision. And so a lot of times we don't recommend that for a certain level of, if it's a $10,000 dispute, arbitration is probably not the best way to resolve it, because these arbitrators get a lot of money. So that's a big chunk out. And unless you include it in the contract, they're going to split those fees. So it's not the best. And so that leaves, unfortunately, or for, litigation is the best binding option. Oop, I forgot a word here. I see this. So no, I guess I had to. So if your dispute is under $7,500, you can go to small claims court and you don't need a lawyer for that. They get the parties all the time, and it's typically before a magistrate. And many, many times they'll try to mediate it or tell you to go in the other room and see if you can't work something out before they uh, render a decision. But small claims for these smaller amounts can be quite useful. It happens very quickly, and you get your ruling. There's still a collections issue, but it's there. But any other kind of litigation in the state district court, which has a jurisdictional cap of, I think, about $50,000, or the superior court, which has an unlimited monetary cap in the state system. I can't imagine much of what we're doing here being in the federal courts, but things move very slowly, and you almost always need a lawyer to help you navigate the procedural elements of this. And it goes slow. I can't tell you. I have a case I filed in uh, June of 2023, and we just got our judgment right at the end of last year. So and then there's appeals. So, litigation, especially other than small claims, is a you just have to know you're into a slow process there. So that's what I have. It's, again, to go back to where I started. Excuse me. Your comprehensive agreement is your best defense than anything else that you might come up with later. And then if you start to deviate or you can't get those terms of the agreement enforced, then you want to try the getting to yes appropriate negotiations there, and then escalate as you need to move it forward. So if there are no questions, I think we are done.
Yeah, I'm giving everyone a chance. There's a couple people here. We're giving them a chance to type any questions they might have into chat. If you wouldn't mind going to that last, there's one more thank you screen.
Oh, okay.
Yeah, and in case anyone would like to follow up with a mentor on this topic or any other topic, you can use that QR code there to submit a form there, and we'll get you matched to someone as soon as possible. Um, and if you'd like to if you have any questions, please go ahead and get those into chat right now, and we will get those answered for you. And if you think of it later, go ahead and email me at connect@bbmentors.org, and I can get that forwarded to Bill so that he can answer that question for you.
Yep.
Um,
Shall I stop sharing?
yep, Not seeing anyone typing, so I think we might be, I'll go, it might be okay to go ahead and wrap up. So thank you, Bill, very much for
You are welcome.
sharing your expertise today. And we hope to see everyone on a future presentation. Thank you, everyone.
Yep. Bye bye.